Once the father comes to court and he's not able to explain why he has not been able to pay the child support despite being a man of means, then the court can actually commit him to civil jail. My name is Caroline Janja, an advocate of the High Court of Kenya with more than 7 years of experience working in child protection, human rights, access to justice. I'm currently working as the legal consultant for Crime CPOA, and thank you for joining us today for the Ask a Lawyer series, and today it's day 2 of the Children and the Law segment. Question number 1. My ex-husband refuses to pay child support despite being ordered by the court to do so. When he does pay, it is half the amount he is legally required to pay. I am struggling to provide for our 2 children, yet he is very rich and refuses to support his children out of spite. What legal action is available to me in this matter? Now that you already have a court order, what you can do is apply for the enforcement of this. And one of the things you'll be asking the court is to issue a warrant of arrest against the father of the child, so that he can be taken to court to explain, to show cause as to why he has not paid maintenance. So the court can either issue a warrant of arrest, or it can issue summons for him to be produced in court to explain as to why he has not been able to pay for maintenance. When you're making the application, is to also tell the court how much this person is supposed to pay, how much has been paid, and how much has not been paid. Then once the father comes to court and he's not able to explain why he has not been able to pay the child support despite being a man of means, then the court can actually commit him to civil jail for a period of 30 days. So that he can comply with the court's orders. So with the New Children's Act, there is a new introduction for distress against the father's property. If this is a person of means, then the court can also issue warrants for distress, such that this person's properties can be attached, they can be sold, and the proceeds can be used to settle the child maintenance debt. But before the court does this, it has to have ascertained that indeed this person is a man of means. He has probably misled the court to believe that he does not have a way of paying for this child maintenance. This is usually a last resort, but the best way is to apply for, is to make an application to the court for enforcement of the court's orders. Sometimes you also find that sometimes they are not able to, if he's not able to pay maintenance, maybe because he has had challenges with financials, then the court can take consideration of these new circumstances, but with sufficient proof, and the court is convinced that the person cannot be able to sustain the child maintenance as per the earlier order, then the court can vary the order, but it will not relieve him of his duty to pay parental responsibility. So this is to encourage those parents whose co-parents have refused to obey to the court's orders, that the law is able to help them to be able to get the partners to provide their maintenance as required by the court. Question 2. My niece, age 16, recently became pregnant. My brother beat her up and kicked her out for shaming his family. She survived on the streets for a while before I searched for her and took her in. Does this qualify as child neglect on my brother's part? Can the law force my brother to take his underage daughter back in and provide for her? Yes, this qualifies as child neglect, because child neglect has been defined to mean that when you willfully or knowingly cause a child to be in need of care or of protection, then you are contributing in a way for this, for the denial of these child rights. So it is true, it is correct to say that your brother actually neglected their child, and this is a criminal offense, which is is a criminal offense, and one is liable to an imprisonment term of at least a maximum of 10-year sentence, or a fine of 500,000 shillings or to both. So this is a very serious offense. But because we also to commit the father to jail and probably even lose out on more, then you can always go to court and ask the court for a child maintenance, for a care and protection order, whereby the children is taken back to the care and protection of their parent, and they are actually authorized to take this child back and to provide the correct, to provide the right care and protection to this child. But where this is not possible, because sometimes you don't want to take back children to the same environment where they were abused, then you can get a care and protection order where this child is put maybe in your custody, but the father is made to cater for everything else that this girl needs, the school fees, the food, the accommodation, but not to live physically with the parent until such a time where maybe this the tense relationship has subsided and now they're in good terms. So this is doable. The parent can actually be compelled to take the daughter back into his care and provide for her. The third question: the father to my 1-year-old daughter left me when I was pregnant and has since refused to acknowledge his child or fulfill his parental duties. Despite asking him for financial help to raise our daughter, he has never given me a coin. What legal action is available to me in this matter? As I said in the earlier part on custody, one, you can first take the matter to a children's officer or an advocate of the High Court of Kenya, and you try to come to an amicable solution pertaining this issue, because now you'll be having an independent expert to mediate between yourselves. If this does not become successful, then you can now go to court and make an application for maintenance. Because from this question I get that you're not necessarily asking for custody, but you can do an application on maintenance and custody of this child, compelling this father to fulfill his parental responsibilities toward this child. So you can always take this child to court, and if the father is perhaps contesting paternity of this child, then you can always make an application for a DNA test to be conducted. And once it is ascertained that this man is indeed the father of this child, then the court will make the right maintenance order requiring him to fulfill his parental responsibilities. So that is one of the avenues you can get a legal solution to your problem. So thank you. That brings us to our segment, at the end to our segment for today. Thank you for your questions and even taking the time to listen to me. And I hope we can interact more on our Facebook page, where we have virtual legal awareness sessions on Tuesdays and Thursdays. So if you have any questions or anything that you need to be clarified, you can visit our page and we can get to assist you further. And that brings me to the end. Thank you and bye.